Today we're going to talk about the Second Amendment and Donald Trump and the judges that Donald Trump picked for the federal bench and why that alone justifies supporting Donald Trump for president, in my opinion. You may not like parts of Donald Trump or things that he's done, but the reality is when it comes to the Second Amendment, he is undeniably better than Joe Biden, and I think he's great. And I'm going to prove to you right now why I think that's the case with the list of judges and their Second Amendment related rulings that we would not have gotten without Donald Trump as president. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so we have to talk about Donald Trump and the Second Amendment. I know some of you don't like this, but I'm perfectly fine doing it. I think Donald Trump is the best Second Amendment president we've had in 150 plus years, undeniably so. But I don't want to talk about all the details of why I believe that. I want to focus on the most important thing by far of why Donald Trump supports the Second Amendment undeniably, and that is his selection of federal judges. Not just Supreme Court justices, but all federal judges. This is mission critical to understand. And of course, whatever you want to say about President Trump, he is certainly 1,000 times better than Joe Biden. So again, between those two, you really have no choice in my view but to support President Trump. But standing on his own 2 feet, I think Donald Trump is great on the Second Amendment. I'm happy to debate that with anybody at any time. And with that said, I think the best evidence of this by far is who sits on the federal bench right now and what they've done to protect our Constitution, including our Second Amendment. And I'm going to go through just a quick list here, which I will also display, and I'll put I'll try to find a way to put this on Twitter or something so you can cut and paste it. I just want to give you the list of federal judges and the Second Amendment, favorable Second Amendment decisions that have been issued thanks to these picks by Donald Trump to the federal bench. To begin with, let's just start with the obvious one, the United States Supreme Court. Thanks to Donald Trump, we have Justice Neil Gorsuch, Justice Brett Kavanaugh, and Justice Amy Coney Barrett on the Supreme Court. That gave us, of course, NYSERPA versus Bruin, which without those three, we would not have gotten NYSERPA versus Bruin because, as you know, the Rogers case out of New Jersey several years prior to that was up for cert, and that involved may issue carry regimes as well. That was denied cert. We did not get that. Only after Donald Trump's picks went on the federal bench did we get NYSERPA versus Bruin, which is a huge victory for the Second Amendment. We would not have gotten without President Trump. That is in addition to the other victories brought about by the current Supreme Court with 3 Supreme Court justices picked by Donald Trump, including knocking out affirmative action in higher education, dealing with these January 6 defendants and sort of the crazy indictments being brought by the Department of Justice associated with that by Jack Smith and the Department of Justice, likely getting rid of the Chevron doctrine, and so on and so on. So that's just the Supreme Court alone. So if Donald Trump did literally nothing else on the Second Amendment, his selection of those 3 justices stood up and gave us NYSERPA versus Bruin, and they're going to give us a lot more. You'll see shortly. That alone justifies, in my view, concluding that Donald Trump is very good for the Second Amendment. But let's go far beyond that. Let's look at his lower court judges. Keep in mind, I always point out that Article 3 of the U.S. Constitution creates a single Supreme Court, which we often talk about, but it also creates so-called inferior courts. And that is what Article 3 says, not just what I say. Lower courts are inferior courts. Let's just go through the list of the judges that Donald Trump nominated that was confirmed to the federal bench and the decisions they've issued involving the Second Amendment. And in no particular, I'm going to start with the Court of Appeals judges that he picked, their rulings, and then we'll go down to the district courts as well. To begin with, let's start out in New Jersey and Pennsylvania and Delaware, the Third Circuit Court of Appeals. You have Stephanos Bibas, David Porter, Paul Mady, Peter Phipps, all of whom were appointed to the federal bench by Donald Trump, and all of whom were critically important for that major victory dealing with nonviolent felons in the Range versus Garland case, which is now up before the Supreme Court, waiting for whether or not it's going to be granted cert. This was a major en banc win, powerful Court of Appeals decision applying the Bruin standard. Again, these judges picked by Donald Trump, Stephanos Bibas, David Porter, and Paul Mady, as well as Peter Phipps, mission critical for us getting that huge Second Amendment victory in Range out of the Third Circuit. But let's go down to the Fifth Circuit. Again, right now I'm only talking about the courts of appeals Appeals. We're going to get to the district courts in a minute. At the Fifth Circuit Court of Appeals, obviously a huge series of Second Amendment-related wins thanks to Donald Trump appointees. Let's just start with the Rahimi versus the United States case, which is before the Supreme Court now. The decision by the Fifth Circuit was by two major judges appointed to the federal bench by Donald Trump. That's Corey Wilson and James Ho, both of whom are probably on the short list to be on the U.S. Supreme Court. We'll see what happens. But Corey Wilson and James Ho gave us the Rahimi decision saying that basically domestic violence restraining orders are not sufficient grounds for denying somebody the right to keep and bear arms without massive amounts of evidence, and so on and so on. And this facial challenge to that statute was declared unconstitutional by two Trump-appointed judges. But let's move on. You have the Vanderstock case, which is before the U.S. Supreme Court dealing with a quote-unquote ghost gun problem, which of course is a political propaganda term by the anti-gun lobby. What ghost guns are is really unserialized firearms. We're going to be doing a lot of videos on this, but the reason why the Department of Justice and Merrick Garland got their butt kicked in the Fifth Circuit, and now they're before the Supreme Court, is because of three Donald Trump appointees to the United States Court of Appeals for the Fifth Circuit. That would be Andrew Oldman, Kurt Engelhardt, and Don Willett. Again, Andrew Oldman, Kurt Engelhardt, and Don Willett all gave rise to the Vanderstock decision in favor of the Second Amendment against the ATF. Even though this is not specific to the Second Amendment, anytime you defeat the ATF and narrow their responsibilities and authority, that is a win for American gun rights. Then we have other decisions out of the Fifth Circuit involving Donald Trump judges, including, of course, the Cargill versus Garland case dealing with the Bumpstock issue that said that the Bumpstock ban, and we can talk about whether or not Donald Trump should have done that in a second, but the Bumpstock ban that was done through executive order during the Trump administration, that's true, in Cargill versus Garland was declared unconstitutional by a whole host of Donald Trump appointees to the federal bench. That included Corey Wilson, James Ho, Andrew Oldman, Kurt Engelhardt, Kyle Duncan, and Don Willett, all of whom ruled in favor of the Second Amendment against the ATF in the Cargill case involving bump stocks. By the way, as a digression, you must remember that the debate at the time was whether or not to ban bump stocks, and the concern was that Congress, in attempting to ban bump stocks through legislative action, would 100% screw up the definition of what a machine gun constitutes, and in doing so would screw it up in such a way that would broaden the definition of machine guns. It would cause basically all semi-automatic, gas-powered, gas-operated rifles and the like to fall under the definition of machine guns, because unfortunately the Republicans on Capitol Hill, as a general matter, are not great lawyers. They're not great negotiators. I hate to say that, but it's simply true. And if you allow Chuck Schumer to try to redefine machine gun and broaden it to encompass bump stocks, you would have had something that would have been absolutely terrible in the hands of the anti-gun movement and anti-gun judges in parts of America. So it made sense to get rid of this bump stock issue through executive order, which likely will all disappear hopefully very soon in the Cargill case before the Supreme Court. But again, I understand the logic. I didn't like it, but I understood the logic of why you wanted to ban these through ATF executive order versus allowing Congress to redefine and broaden the definition of machine gun, which would have been catastrophic because it would have encompassed a bunch of semi-automatic rifles. It would have been very bad to let Congress rewrite the definition of machine gun to encompass bump stock, because it would have been overly broad and screwed up, and certainly it would have hurt the Second Amendment. So I do understand the logic, even though I don't love it. Nevertheless, that is why Donald Trump did that executive order through the ATF, and I do get the strategy there. Sometimes you have to lose small battles to win the overall war. I do understand that. But let's go on with other major judges that Donald Trump put on the federal bench and why they helped out the Second Amendment. In the Seventh Circuit Court of Appeals, remember, Michael Brennan was the dissenting judge in Bevis versus Naperville. Remember, I always talk about Diane Wood and Frank Easterbrook being terrible on the Second Amendment, absolutely total losers on the Second Amendment. Out of the United States Court of Appeals for the Seventh Circuit in Chicago, we've talked a lot about them. I've made a lot of fun about them, and there's nothing I say about them that is unjustified in my view. With that said, there was a 2-to-1 dissent in those cases involving the Illinois quote-unquote assault weapon ban and the magazine ban. There was a dissenting opinion. That dissent was by Judge Michael Brennan, who was appointed to the Seventh Circuit Court of Appeals by Donald Trump. So you cannot blame Donald Trump for that Seventh Circuit Bevis decision involving assault weapons, because that was brought to us by judges from other presidents. But the Donald Trump president in that case ruled in the right way. And again, we'll get to the lower courts as well. That was also the case. Also, don't forget, out of the Seventh Circuit, then Judge Justice Amy Coney Barrett was the one that wrote a very powerful dissent in Cantor versus Barr, which really got the ball rolling for how you interpret the Heller decision properly, with text first and history second. In her dissent in Cantor versus Barr, where she said nonviolent felons do not automatically and should not automatically lose their right to keep and bear arms under the Second Amendment, and that 18 U.S.C. 922 G1 should not be assumed to be constitutional in all instances. She got that ball rolling with that powerful dissent in Cantor versus Barr by then Judge Amy Coney Barrett. Of course, now she's on the U.S. Supreme Court. Then we move over to Minnesota and Missouri and whatnot. In the United States Court of Appeals for the Eighth Circuit in the middle of the country, you have some very powerful potential future Supreme Court justices on that bench brought to us by President Trump's nominations. That would include David Strauss, Jonathan Kolbs, Stephen Gratz, Ralph Erickson. We all know they're good on the Second Amendment because they all dissented in a case called United States versus Jackson, which dealt with whether or not nonviolent felons should be denied their right to keep and bear arms for life. There was a decision by the Eighth Circuit to deny en banc review, but there was dissents by, again, David Strauss, Jonathan Kolbs, Stephen Gratz, and Ralph Erickson, all Donald Trump appointees. Then go out to the Ninth Circuit Court of Appeals. Obviously, we know the Court of Appeals for the Ninth Circuit in California, Hawaii, Oregon, and Washington and whatnot is absolutely a generally overall crappy court when it comes to the Second Amendment. That's because the majority were appointed to the federal bench before Donald Trump. With that said, there are some very bright spots out there of great judges in support of the Constitution and the Second Amendment. That includes, for example, Kenneth Lee and Lawrence Van Dyke, both of whom issued a powerful decision in the case of Junior Sports Magazines versus Bonta, which enjoined the law, the California law that prohibited advertising firearms in a manner that was attractive to minors. This was declared basically unconstitutional under the First Amendment and the Second Amendment. Very powerful decision by Judge Kenneth Lee and Lawrence Van Dyke, both of whom were appointed to the federal bench by President Trump. Then you have other decisions by judges in the Ninth Circuit Court of Appeals favorable to the Second Amendment. Yes, it does occur. Often it gets en banc by the nutty liberals out there, but you do have good decisions, at least initially, and thanks, not exclusively because, for example, Judge Benitez is not a Donald Trump pick, but you certainly have other Donald Trump appointees that have done a great job when applying to our Constitution in the Ninth Circuit. For example, Daniel Collins and Kenneth Lee were in the majority in the Teeter versus Lopez case that said that Hawaii's ban on butterfly knives was unconstitutional under the Second Amendment. Then you have Patrick Bumate and Ryan Nelson, and again Lawrence Van Dyke, all of whom dissented in Duncan versus Bonta, whether or not that case should be reheard. Remember, Duncan versus Bonta is the California magazine ban on so-called large capacity magazines, which of course are really just standard capacity magazines. But again, you have three Trump appointed judges, Patrick Bumate, Ryan Nelson, and Lawrence Van Dyke, obviously said that this should not be heard en banc pretty clearly where they come out on the Second Amendment when it comes to these issues. And of course, just recently, in the United States versus Duarte case, Judge Van Dyke again issued a ruling in a 2-1 decision in the U.S. versus Duarte case that 922G, 18 U.S.C. 922G, which is the felon in possession law, does not apply to nonviolent felons. There is no historical analog rules or laws that would justify such a lifetime ban for a non-violent felon under the federal definition. So again, another victory in support of the Second Amendment, in large part because of a Donald Trump pick to the federal bench. Now let's move down to the United States District Courts. These are the trial courts, the inferior courts at the lowest level of the federal system for Article III courts. And let's talk about Donald Trump's appointees and how they've supported the Second Amendment right to keep and bear arms in their decisions. Again, this is all to illustrate the point that these are the kinds of judges that we're getting because of a Donald Trump presidency. And we certainly are not getting these kinds of judges because of a Joe Biden who's picking justices and judges like Brown Jackson, right? That's the kind of thing that we're getting. You know what that means and the quality of that lawyering and that judging. With that said, let's look at some of the district court decisions. First of all, in the Middle District of Florida, United States District Court, Catherine Mizell, very good decision in the United States versus Ayala, which ruled that a ban on carrying guns in post offices was unconstitutional because it was not historically a quote-unquote sensitive place. Catherine Mizell, powerful decision there in the Middle District of Florida. Then we have in the Northern District of Illinois, Stephen McGlynn. You're quite familiar with him because in the Harrell versus Rao case, he's the one that issued a preliminary injunction, a long, detailed preliminary injunction saying that the Illinois quote-unquote assault weapon ban was unconstitutional under the Second Amendment. It was his injunction that was overturned by the nutty anti-gun judges who are bitter they're not on the Supreme Court, Frank Easterbrook and Diane Wood, there in the Seventh Circuit. It was the decision by Trump appointee Stephen McGlynn that was overturned by that nutty 2-1 decision with Easterbrook and Wood in the majority. And of course, the dissent was by Trump appointee Michael Brennan, as we've discussed before. Then you have in the Southern District of New York, the U.S. District Court for the Southern District of New York, Judge Cronin in Score versus the City of New York declared that New York's good moral character requirement was unconstitutional as a matter of an improper licensing regime there in the City of New York. Again, another Trump appointee, John Cronin. Then you move down to the Northern District of Texas where you have Matthew Kacsmaryk in Brittle versus Garland. He enjoined the ATF's pistol brace rule. Then in the District of the Western Virginia, that's the United States District Court for Western Virginia, you had Tom Klee in Brown versus the ATF enjoined the federal prohibition on FFL selling firearms, or specifically handguns, to 18 to 20-year-olds. That was the order by Trump appointee Thomas Klee. Very powerful decision. But then you move on out to California. Again, I'm just giving you the highlights of this just to show you that these are the judges that are on the federal bench because of President Trump's judicial nominations. Now, obviously, he had help, but if he seeks the right help and gets guidance from the right people and trusts their advice and he gives rise to good results, we should applaud that and not tear him down. Donald Trump also put on the federal bench John Holcomb out there in the Central District of California. And in the B&L Productions versus Bonta, he struck down the ban on gun shows that were being held on public property. Again, John Holcomb striking down the ban on gun shows that were being held on public property. They tried to ban that, and that was declared unconstitutional. Then we go to the District of Columbia. We have Trevor McFadden, who has done a very good job in these January 6 cases, holding the DOJ's feet to the fire. There have been several instances where DOJ has tried to get individuals to give up their right to keep and bear arms as part of this, plea deals and probation deals and whatnot. And Judge McFadden has been very aggressive in saying, no, you can't get away with that under the Second Amendment. You have a right to keep and bear arms. You cannot deny people the right to self-defense. And last but not least, we have Patrick Wyrick out of the United States District Court for the Western District of Oklahoma in the United States versus Harrison case that held the law unconstitutional, where the law banned marijuana users from possessing firearms. So again, this is a smattering of decisions that are supportive of the right to keep and bear arms. They apply to the proper methodology to get to the right outcome. These are all people that are on the federal bench today for the rest of their lives because of President Donald J. Trump. So whenever anyone says to you, Donald Trump is not good on the Second Amendment, he's not good on guns and whatnot, you remember this list, because there is no more important job that a president can do to protect our right to keep and bear arms than make sure that federal judges respect the Constitution as it was written, including the Bill of Rights, including, of course, the Second Amendment. Now, of course, I should just also note, you cannot point to a single piece of legislation that Donald Trump signed that gave rise to more gun control in any respect. Yes, he said something stupid one time about taking the guns and then giving them due process, but I don't hold that against him because, he's not a lawyer and nothing happened with it. He says all sorts of things. We say all sorts of things. I've certainly said things were wrong and got fixed. So the fact that he made a comment that never went into law and never went anywhere, you can't hold that against him. I mean, the guy's not a lawyer. Again, the only criticism to me that's legitimate on the issue of gun-related issues in the Second Amendment is his decision to enact the Bumpstock ban through regulation. But as I pointed out, that could have been a victory, a loss of a particular battle, a narrow battle that no one's happy with, but it prevented the loss of a much bigger battle by denying Congress the ability, if you will, to go out and broaden the definition of machine gun, which is what they would have done to encompass Bumpstock bans. And the way I think they would have done it is to include the phrase rapid fire or rate of fire in the definition of machine gun, which is not there right now. And had they done that, that would have opened us up to a whole host of headaches where the anti-gunners would have tried to argue that the new federal definition that encompassed bump stocks also would have encompassed, they would argue, semi-automatic rifles like AR-15s and anything that's gas operated and so on and so on. Nevertheless, by Donald Trump doing what he did, strategically, I think makes sense. Did I like it? No, but was it strategically smart? Yes. And at the end of the day, Donald Trump is far, far superior to the nutjob anti-gunner Joe Biden. So again, anyone who disagrees with what I said or thinks Donald Trump is not the right pick for president over Joe Biden, I think needs to have their head examined and needs to grow up and recognize in today's world you have to pick between alternatives that are not utopian and not perfect, because there is no such thing as a perfect person or a perfect situation. It's just not the way the world works. So anyone that doesn't like Donald Trump when it comes to the Second Amendment, I think needs to grow up and realize that, yes, he's still the best man. And I still think he's the best person on the Second Amendment that's sat in the White House for the last 150 years. Okay, so there you have it, folks. Hope you learned a little bit something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.